Oh, sorry. Item 4, the minutes. We're not passing on the minutes from the November 2nd meeting today. They will be handled along with the minutes from today at the continued meeting on January 18th, 2013. Apropos of the minutes, staff has suggested that we might consider requesting a change in the way the minutes are prepared of the clerk of the board. I don't know what your feeling is. The summary minutes that we get are usually just fine, but given the infrequency that this commission meets, I found it difficult to recall from the summary minutes some of the actions that we took in the past. I think that staff's recommendation or point for discussion is whether we might request of the clerk of the board more detailed minutes if the commission feels that's warranted. Any feelings one way or the other? Yeah, there's an additional expense involved, obviously.
Should we take that up as part of the study session on the efficiency of the...
We can do that.
I don't have any objection to having more detail, but it's sort of... Because I'm the one that partially got us into a second meeting tonight last time. Because I was concerned about the number of meetings we were having.
Okay. Why don't we just pass that matter then?
I think it's a good issue. I think we need to discuss.
Okay, item number 5, commission members and staff comments. Any comments from commissioners? All right, I think that staff is going to give us a brief update on the 2012 election cycle matters. And commissioners, you will have on your desk a sheet of the 10 matters that are currently pending. So, staff?
Good morning, Commissioners. With respect to the 2012 presidential general election, as of last night, we have a total of 10 cases. They have all been referred to the initial complaint review attorney for review. Of the 10, we have received a total of 7 opinions from Richard Norman. Of the 7, we have 5 cases being referred for investigation and 2 are being recommended for dismissal. At your January 18, 2013 meeting, staff will prepare the recommendation for dismissals of the 2 matters. Thank you.
Chair C, I have one comment.
Yes.
Item 10, part of my responsibilities in our office is advising the Elections Division. 10 involves complaints against the Election Division in enforcing the ordinance. So I therefore will be recused from advising you on that matter, but I will be advising elections on that matter since I have in the past. Another assistant county counsel, I understand, will be assigned to advise you should that matter come before you.
All right. Thank you. All right. Moving on then to item number 7. This is continued from November 2nd. It's the complaint number P10-001, Fonte versus Strickland.
Good morning,
Mr. Steele.
Good morning, Mr. Chairman, members of the Commission. Craig Steele, your outside investigator. If it pleases the Chair, I can report on 7 and 8
Great.
together. We have reached a stipulated resolution of both of the items in number 7 and 8 on your agenda. We agreed with counsel for the respondents on the final language of the settlement yesterday, and the respondent is in Florida for this week, so I've not yet received the check for the payment of the fine. So the stipulation and the complete packet of information will be before you for consideration and approval in your January meeting. But we have reached a full resolution.
It is my understanding then that respondent has no objection to continuing this matter to January?
No, the respondent has agreed to continuing it to January in order to get us the check and the fully signed stipulation for your consideration.
It's the pleasure of the commission.
Can we be advised of the resolution?
Well, because you're going to be considering it in a commission meeting, I would prefer to have it before you. It involves a full resolution and a payment of fine. But I think it's
Just
probably...
a hearing, I mean, we just continue the hearing. It's the
Pardon me?
same. It's a hearing on this matter, and we can continue this hearing. So any evidence taken now will be considered at the January 18th.
I presume it will be scheduled and noticed as a new item on the January 18th agenda. Is that correct?
Yes.
I'll defer to counsel and...
Unless counsel for the respondent in those cases had any objection to you relating what the outline of the settlement is, I don't think there's a legal problem with you outlining that today. They're not taking any action on it today.
Okay, I didn't discuss it with counsel at all, and I don't think the respondent is represented
That's true.
here. But I mean, that there's no secret about the resolution. Both matters are resolved. The two cases that are listed on your agenda, there's an agreement to pay a $700 fine and a full stipulation as to the facts of the matter. And a waiver of the, I'm sorry, left this part out, and a waiver of the legal challenges that were threatened in the letter from the respondent.
The constitutional issues on the inter-candidate transfers?
Yes. We agreed to disagree on that issue, but there will be no further legal challenge to this enforcement matter.
Okay.
Anything further on this matter? Thank you, Mr. Steele.
Thank you.
We're not really continuing it, are we? It will be agendized as a new matter on the January 18th. Ms. Lee?
Well, the hearing's a hearing.
Oh, the hearing.
I mean, this is a hearing. We're holding on it, and I would think that the hearing's being continued to resolve it. So I would think that it would be a continued hearing.
Do I have a motion to continue items 7 and 8 to January 18th?
Second.
All in favor? Aye. Hearing no objection.
Aye. Sorry.
Okay. Now we're going to move into item 6 and receive first a staff report from Ms. Lee, and then into the discussion study session under item 9. Ms. Lee?
Thank you. Item 6 is a staff report outlining the salient points of our November 2nd meeting discussion. I provide the Commission a brief history regarding the 2010 gubernatorial primary election as well as the current 2012 presidential general election matters. We had a lengthy discussion about the complaints, the process of how processing the complaints and the reports of apparent violations, and how quickly those matters are being resolved or unresolved. So the Commissioner asked that today staff will also bring together during the discussion session, we'll be talking about the process, the differentiations between the report of apparent violation versus a formal complaint. I also outlined for the commissioners the various stages of the processing of the complaint, moving in from the initial complaint review stage to the investigation stage, and the timeline it takes for each matter to move through the queue. So if you have any questions on that staff report, I'll be more than happy to take your questions.
Are there any questions of staff at this point? Thank you. Do I have a motion to receive and file staff's report in connection with item 6? Second. Any objection? All right. Now, the study session and report to the Board of Supervisors, we were going to discuss financial efficiencies of the administering the ordinance and make recommendations accordingly. My recollection was that there were several issues that we wanted to address in that context. We were going to have a discussion on the time frame for resolution and discuss potential amendments to Section 1296D of the ordinance and the appropriate changes to our rules and procedures as well, operating policies. We had requested that elections attend and give us some discussion and report on the difference between a reported violation and a complaint from their perspective, since elections may decide to institute an action using either format. So, should we take up the issues regarding time frame for resolution at this point? All right. And Ms. Lee has set forth the basic time regulations or limitations. We have a 90-day period from filing to a time that there ought to be a report to the commission. 30 days for complaint review by Mr. Norman, 60 days for investigation by Mr. Steele or the investigating attorney, and then a hearing or further proceedings in connection with that before the commission. The initial discussion was, I think Mr. Becker was concerned about having a resolution of the matter during the period of time of the election cycle. Now, obviously, with a 90-day time period, that's not always going to be possible. There will be violations and complaints filed within 90 days of the election that cannot reasonably be handled. On the other end of the spectrum, we have matters which are still hanging around from 2010, which the commission felt was an unduly long period of time to resolve it and deprive both parties of a prompt resolution and disposition of the matter. Any comments?
Well, I'm not sure how much of the study session was the result of me making comments last time, but I guess my reaction was less the getting down into the procedural things and more the whole question of, in light of Citizens United and the things that we read in the paper every day. For example, the Arizona $11 million contribution, that after going through all the litigation in order to come to a conclusion that, yes, you have to say who it was that provided the money. And so they said, okay, and they gave them two more shell nonprofit corporations that didn't have to tell who the identity was behind the other two shells. And I'm just thinking in light of all of that, the whole idea of what we do here, if we can't do it in a timely way, and it seems like from a due process standpoint, it's very difficult to do in a timely way and give everybody their rights. And when the conclusion is that we end up with a $400 fine, which is hardly postage for most campaigns just to get their committee together, I mean, it's an insignificant amount. It's really I guess, my question is, the idea is good what we do. And, you don't want to not do audits just because you haven't found something wrong in the audit, because by having the audit, that has a certain effect on keeping everybody in an organization, keeping the books correctly. So by analogy, not to have an ethics commission because we haven't had any significant violations or things in which we are penalizing people doesn't necessarily mean it's not working, but if you'll permit me a corny old story of the elephant powder, where a man moves into a neighborhood and when he goes out to get his newspaper, he discovers his neighbor sprinkling powder around the perimeter of his property. And after about the second or third morning of watching this, he inquires of the neighbor, what exactly are you doing? What is that stuff? And the fellow says, well, it's elephant powder. And if you know the story, it's, well, what is elephant powder? Well, it keeps elephants away. To which the neighbor said, well, my God, man, don't you realize there's not an elephant within 5,000 miles of our neighborhood? And he says, yes, it's very effective. I mean, it's sometimes hard to prove where we are, but I was just looking at, we've spent $50,000 and a lot of staff time, and we've got one $400 fine, and we've got 10 complaints, 7 of which were filed by the elections office, and they were apparent violations. And I was just wondering, if, in light of Citizens United and the spending limitations and everything, whether, I know we don't make this decision, but suggest to the board that they take another look at either we, what kind of a contribution are we making to actually controlling things. So anyway, that's...
Well, perhaps you would like to combine those comments with a reflection on the amount of money that the commission is costing us. I don't know whether, as part of the study session, you wanted to refer to the fines and time in that overall context.
No, well, I was just thinking that it is, according to the staff, they've in the last couple of years, they put in like $50,000 either in money or staff time. And, that's not a huge amount of money to achieve a good purpose. But I'm just wondering, in light of what's going on beyond everybody's control here in Ventura County, whether either we need to do it a little different way or whether we need, to do it at all for the time being was, the only observation. I don't know exactly how that gets, put into a report, but...
I guess part of it is has anybody looked at the benefit of the process? I think that's what you're asking. I mean, has anyone looked and said, notwithstanding the cost and how cumbersome it is, it still has, the elephant powder. I mean, it's still... There is still some value to the process. And I haven't heard anybody stand up and say, yes, there is a value to this process.
At least, yeah.
Not yet, yeah. And is that the question that we even ask? I mean, the decisions are made elsewhere on whether to have this element as part of government, this commission.
Well, the obligation to report back, on, I don't know what, activity and effectiveness or efficiency, I guess, to the board. I'm not sure how we do that, other than to say, yeah, it costs this much money, we've had this many complaints, we've had one fine. I guess the thing that was most disturbing is when Mr. Becker pointed out that the cases that seemed to have something to them were from 2010, and we were already into the next election cycle, and so what effect did that have on anything?
Well, the reality is that you really cannot resolve these in that election cycle. I mean, the time period is too short.
But 2 years?
Well, that's troublesome. And we talked about this last time. It's very troublesome to have cases go on that long. Right. 3 months maybe, but I think anything longer than that is just improper. We need to have a procedure that moves things a lot faster than what we have. But it will never. I don't think it'll ever be resolved in that cycle. Yeah.
Well, we had the benefit and a request to speak in having Supervisor Bennett, one of the authors of the measure that we're discussing, present here today. Maybe this is an appropriate time to hear from Supervisor Bennett on the issue.
Well, thank you very much, and let me start just by saying thank you for giving up your time to come and be part of the commission. I think the first question I believe I'm hearing you asking is, are you having any impact? Is there value of doing this? And I just would like to say emphatically, yes, you are having impact. First of all, I'd like to point out to you that this is a relatively new issue for Ventura County, and it is one that, because of a variety of reasons, because elections only come along certain times, you only meet a certain number of times, it is a process that is going to evolve slowly. And I'd just like to put in perspective where we are in the process, and would suggest that your conversation today and what you're doing today is exactly what we need for the process to continue to evolve, which is to scratch your head and say, now this doesn't seem to be working very well, so how do we fix it? 2 years is too long, simply, for these things to have any sort of meaning for the public, for there sort of be, if there's any sort of public sort of embarrassment factor that may go along with being with your finding, it sort of dissipates after the violation becomes 2 years old. But I believe certainly we're making progress, and we can get there, and we actually need you and the role and the questions that you're asking today to be able to make that happen. So I really hope that you will make a recommendation to the Board of Supervisors. That's how we will be able to, we tweak the ordinance every 2 years after the election cycle and before the next election cycle. So the next election cycle starts next June. And between now and next June, we will come with our suggested modifications and changes. And a lot of that will be things to, not necessarily big changes in the ordinance from the standpoint of what you can and can't do, but procedural things that will make it better. We're trying to figure out what is a cost-effective way to still accomplish the goals that we wanted to accomplish. So let me put into perspective one thing, and that is the issue of where we can be cost effective. Justice delayed is justice denied, but hasty justice is not justice, either. I think that's the issue that we're trying to challenge. You saw with the State Fair Political Practice Commission got very active before the election, trying very hard to get for the public the right to know where the money was coming from in Arizona. Now that was, I think everybody could say, that was an appropriate action on the part of the Fair Political Practice Commission to try to get to voters valuable information before voters had to make decisions on that. And I would offer that's an area where we probably should focus and try to improve. That anything we can do to make sure that the public knows this message was paid for by this person is good for democracy. And that's an area where we probably don't want to wait 2 years when somebody doesn't file and doesn't disclose who they are, and it's very apparent that they are hiding that we ought to probably amp up the ability of the commission to be assertive in that situation and say, we're not trying to find out who's guilty or who's not guilty yet, we're trying to find out the information. So one of the roles, I would say, somebody used a term the other day, so who's the chief enforcer? And I said, well, the first question we have to ask is, who's the chief informer? Who's the chief person to make sure we all know? And then if people aren't doing things kosher, if somebody's laundering the money and doing some of the more egregious things to hide that, then that's where we have the enforcer side of it. But when we have very apparent efforts to hide who's paying for something, that's an area that I would welcome the commission saying, hey, you'd like to ramp that up, you'd like to get involved in that and try to make that happen. Second question is $50,000 worth it? It reminds me a great deal of our senior long-term care ombudsman program that I say oftentimes. Some of those volunteers, they have about 65 volunteers, and they go around, they check every senior nursing home every week to make sure nobody's being neglected or abused, etc. And some of them scratch their head and say, well, what good am I doing? I know everything seems to be fine every week when we go. And a wise person said, to them, I thought it was really sage when I heard it, it says, you don't know, the fact that you're going is why those seniors are not being neglected sometimes, right? Why they're not being abused, because they know you're coming, because they know you are here. how much abuse of the system is not taking place if you didn't exist. And I want to offer to you in this most recent election experience that happened with me. I only found out very late in the election that an independent expenditure committee had formed quite a bit earlier, right? In the month of September it had formed. In fact, it had actually filed. I wasn't notified until the end of October when I went down and found it and pointed out that I was supposed to be notified, et cetera. But I would point out to you that finally, at very late in the election, but still about 12 days before the election, that committee felt compelled to start revealing how much money they were spending. And with the way our ordinance is written, somebody who has accepted the voluntary expenditure limits, we have written in there that if an independent expenditure or a combination of independent expenditures goes above a certain amount of spending, this person's no longer held to the voluntary spending limits, because it would disadvantage them tremendously if somebody dumps $500,000 in and they're still locked at the spending limits. I was able to find that information out and therefore make some modest adjustments at the very end of my campaign. It would have been far better if I would have been able to find it out sooner. But that's a whole other issue for you to be addressed, and I filed a number of complaints about that to try to bring that to light. But my point is, if you didn't exist, if there wasn't this possibility that you were going to exact a significant fine, I'm not certain that 12 days before the election, or however many days it was, that we would have gotten that information. And I'm not certain what changes that would have had on the election. So it is the amount you're preventing, the amount of abuse you're preventing, and two, when we do get some clear notification, we seem to be able, I think, to get people's attentions who are violating the law because they know you're there and they know something is going to happen in that situation. So I believe there is a real strong benefit to the process. The only other two things I'd like to mention to you is that besides timeliness, I think I'd like to put in perspective why we have sort of the system that we have with the investigating attorney versus the review attorney, et cetera, is that at one point in time, a report came to us that we had spent, I believe, about $200,000 on relatively on issues that didn't result in fines bigger than $400. So many things were dismissed, et cetera. And one of the things we saw was that the review attorney then became the investigating attorney. And so there was a perception that there could at least be a potential conflict of interest, that if I review this case and I find probable cause, then I also get to be paid for doing the investigation, and then I do the investigation and I find there is no violation. So there could be perceived at least a perception that somebody would have an incentive to find probable cause when it didn't exist. What we're trying to do, I believe, is trying to find that proper perspective where certainly nobody's sweeping anything under the rug, but when we have some person who just is abusing the system and filing complaint after complaint after complaint, and it's just all speculation and there's no evidence at all, that we can quickly dismiss those things without using taxpayers' dollars. But at the same time, recognize that it is a very good use of taxpayer dollars to have a good full investigation when they're. So trying to strike that balance is part of what what is important for us to do. And out of that came this idea that the investigating attorney would also come with a potential negotiated settlement for your review. I believe that's an area where we could have some, where we probably could view some need for improvement, because a few things could happen in that process. Number one, it seems that the people filing the complaint probably ought to be consulted about the settlement before the investigating attorney comes up with a potential settlement offer. They should at least be able to present their perspective as to why stronger penalties should not be imposed or would be appropriate in this situation. They may have some perspective on the degree of impact on the public of that issue. So that's one area where it feels a little bit like it kind of goes into a black box. It's being investigated, and the investigating attorney just comes up and says, I'm coming up with this recommended solution. And if there were guidelines from the commission, somehow some kind of appropriate guidelines for those settlements. That could be helpful, so that the investigating attorney is not completely on their own in terms of trying to figure out what might be appropriate. So that's an area that I think is ripe for discussion. I don't have it all fleshed out in my head in terms of what that should be, but I think I would welcome that, and that would be a potential area. But somehow, if there are guidelines for that process, and then also I think if we, in our modifications of the ordinance, actually write your guidelines in, and whether we put that in the ordinance or whether they stay as your guidelines, which is 30 days for the investigation, 60 days, 30 days for the probable cause investigation and 60 days for the actual investigation. Those seem appropriate, and at least within 30 days, if a apparent violation takes place beforehand, the public would at least be notified that the initial review attorney has found probable cause, which could have some impact in terms of the election and it going forward. So we're sitting there trying to figure out what to craft in terms of the ordinance. Very much appreciate that it may not feel as satisfying as I believe it is out there, but I feel very strongly that there are people that respond to the fact that they could be here for this potential hearing. I would welcome. There are some reasons why the commission can't be involved in the investigation more, because you have to sit there as part of the hearing. Why the commission may not be able to be involved, but I believe we can find some things, and there may be some things that we can research about the commission's role in potential settlements after an investigation is done. If the investigating attorney feels like, yes, there are facts here that suggest that a violation really has happened and we now have leverage, I'd like to investigate that more in terms of what we can do with leverage. I would also like to have modifications to our ordinance so that the commission is empowered to meet quickly and do something with very obvious apparent violations. Somebody has written onto their report that they've received a contribution of $5,000 and they could only take $700. I'm not sure that we have to wait for 2 years to get that resolved, right? I mean, if those are apparent, and at least perhaps it was an error, or perhaps it was an oversight, or perhaps whatever it could be. Or if somebody has simply not filed the report at all that was supposed to be filed, that the commission could compel very quick, prompt disclosure of that. And I would leave you with that as the other thing, and that is the name of the game here. I mean, Dan Walters, I couldn't believe what he wrote shortly after the Arizona ruling. He said, he was apologizing, he was sort of defending. He says, the people in Arizona played the game well. They used legal maneuvers and ran the clock out until Election Day, right? And the Fair Political Practice Commission has a $10 a day penalty for each day you're late. That hardly compels somebody to say, wow, I better make sure I file on time. I really think that we should have penalties that if somebody is inadvertently late, and this is always the trick, if somebody's inadvertently late, it's one thing. If somebody is blatantly late and is informed and is told, for example, you're late a day, maybe it is a very small amount, but you're informed the next day, and that's what happens. We have to promptly inform people, hey, your report was due yesterday and it didn't come in. Maybe the treasurer's in the hospital or whatever, right? But people need to be informed. But if once they're informed and they continue to be, incalcitrant in terms of filing the proper information, or if we're not doing our job in terms of informing people of that information, then that's where we should have significant penalties that start to apply, when it's sort of this willful attempt to try to hide the information from the public. And so I break things down just in summary. You're having, I think, a significant impact. If there are apparent attempts to avoid disclosure, I think we should try to move with all due speed to compel that disclosure. If there are apparent, obvious violations, particularly ones that deal with disclosure, we should actually be able to have hearings and get resolutions of those things quickly. The other things will take some time. And then to the extent that the investigating attorney, we can have more guidelines, more help for the investigating attorney to know where to go with these settlements. So, because I think it puts the commission in an awkward spot if an investigating attorney comes and says, I've decided to settle this thing for $400 or for $100, and the other side has agreed, and you think this thing ought to be a $10,000 penalty. Well, if we have those kind of discrepancies, probably more guidelines might be helpful at that point in time. So happy to talk. I'm happy to talk more as we try to evolve what should be, but my primary focus here right now in the near future is to get this ordinance right in terms of modifications. And I will guarantee you this, that 2 years from now, we will be going, we got to make some other fixes. It is a process of evolution that will take a considerable amount of time before we even get to the point where we say, we think we got something pretty good. I think we have a big improvement over having no ordinance, over having no commission, but I don't believe we're necessarily at the point where we go, we feel pretty good about it. I feel like we still have process issues and ordinance issues that we have to clean up. Thank you very much.
A couple of quick things. I was glad to hear the explanation of the necessity for a review attorney and an investigating attorney. I questioned in my own mind whether or not that was a wise expenditure and a duplication of effort. Mr. Norman's activities really just test the legal sufficiency of the complaint or report. And then Mr. Steele delves into the underlying facts, and perhaps there is a potential for conflict. I don't know. We have both counsel here. I have perhaps a question of Mr. Steele. The suggestion from Supervisor Bennett was that you consult with the complainant in conjunction with any proposed settlement. Does that in fact happen?
It does not.
Okay. Have any feelings about whether that's appropriate or inappropriate?
I do, and I appreciate the supervisor's comments, I think, which I agree with many of them. The life of these ordinances is very much an evolutionary process. I started in 1991 working with the City of Los Angeles Ethics Commission in setting up the commission and in working on some of their first investigations. And I think in Los Angeles it took 4 or 5 election cycles to get to a point where the commission and City Hall felt like the ordinance had evolved to a point where it was a smoothly functioning and very effective piece of legislation. It continues to evolve today because, frankly, politicians and lawyers will continue to think about ways to do the things they want to do within the framework of laws. So that ordinance in Los Angeles, although it's very heavily enforced, continues to evolve. Political Reform Act was adopted in 1974. They're still working on it. So it is very much, as the supervisor said, a process of evolution, and I think the commission and the board have done a good job of trying to update things as we go forward. I would just say 2 things on with regard to timing. First of all, I think the commission is correct to be concerned about the 2-year time frame on the case that we spoke about today. There's a number of reasons why that got delayed, but 2 years was too long, and that's on me, and that won't occur again. But we have resolved a number of other cases much more quickly than that. I think you will find, though, if your intent is to try to get cases resolved within an election cycle, it's very unlikely that that's going to occur. And in my view, as an impartial person, I don't live in the county and I don't have any involvement in the political life of the county. In my view, it's not a productive thing to try to resolve cases within an election cycle mostly because, well, I should separate cases where a report doesn't get timely filed or something like that. It's a good thing to get reports filed by the deadlines or as close as possible so that voters are informed just on basic campaign filings. When there's a complaint issued, though, I think that it's not productive to try to resolve something like that within an election cycle because the resolution becomes politicized. And the different sides in the complaint have election-related interests in trying to get those complaints pushed forward or delayed. And so candidates and treasurers are not going to want to swiftly move through an investigation and agree to pay a fine because they're not going to want the mailer that goes out the week before the election that says candidate X violated the municipal or the county code and agreed to pay a fine. You're going to find, I believe, that more complaints will be filed for political reasons if there's a rule of thumb that says we have to try to resolve these complaints before the election is over. It's going to politicize the ordinance, in my view. And as far as I can tell right now, the ordinance has not been politicized. That has happened in other jurisdictions, and I think you're ahead of the game because it hasn't happened here. So I would urge you to consider that. I do not think that involving the complainant in the settlement process is a good thing. For one thing, there's almost always going to be a political rivalry between the complainant and the respondent unless the complainant is the elections division. There's almost always a reason that a complainant is studying the campaign reports of a respondent, and that's usually because they're not politically aligned. And so I think if you have a rule that says the complainant must be consulted prior to settlement or during the enforcement process before a case gets resolved, that's going to further politicize the process of investigating and resolving, because a complainant is never going to say a $500 fine or a $400 fine or a $100 fine is appropriate in this instance. A complainant is going to say, if I filed that complaint, it's serious and you should be pushing for the maximum fine.
Why can't you just say, I disagree, and move on? What's the harm of getting the information from the plaintiff?
I think that the complainant has the opportunity to provide input, as we saw in the Strickland cases that are on the agenda today. The complainant has the opportunity to provide input in the probable cause process, has the opportunity to provide information on the violation to the investigating attorney, and has the opportunity to come here and comment to you before a matter is resolved. And I think all of that is a good thing. I just don't think that it would be productive to have a rule that says the investigating attorney has to get the buy-in or input or whatever the term is of the complainant before agreeing to a resolution, because I think that's going to lead to a situation where it's going to be very difficult to resolve these cases.
All right.
Input, I guess it's the noun that's important. Input, consultation, something like that in the process somewhere. I have no disagreement with that whatsoever, and I think that we have seen that complainants do provide input regarding the merits of the case.
So you wouldn't have any objection
I
to
have no objection to that, and we see that now already. My objection, or not objection, my concern would be if I have to consult with the complainant and get some sort of buy-in from the complainant on the resolution of the matter. That's what I'm seeking to avoid.
But you don't object to consulting them?
I do not.
Okay. I had one other question. The way our ordinance is structured, at the point in time that you are appointed as the investigating attorney, you become a party to the action.
Yes.
That's the way the ordinance reads. I'm curious about why you agreed to disagree about an underlying constitutional issue that presumably could affect every inter or intra-candidate transfer in the future, and left it without a resolution.
Well, first of all, I'm not the commission's lawyer. I don't represent the commission as a lawyer. I have no ability, and we've had this discussion before, to give the commission confidential legal advice. And I shouldn't. I mean, I'm acting as a prosecutor, essentially, and not as your legal counsel. You have legal counsel.
But as
At the same time, I have an obligation to look at the law that applies and look at the application of that law. And I have an obligation to look at the outcome that could be, I have an obligation to look at the possible result of the application of that law. And as we discussed a number of months ago on this case, my concern was that the application of that law in this instance would lead to protracted and expensive litigation on the part of the county against the county, which has been threatened by the respondent in that case. And I have to, I think ethically, I am a lawyer still. I think I ethically have to look at the outcome. I have to look at the applicability of the law and what I think about the law and the facts in a particular case. And that's why, in this particular case, we looked at it and agreed to disagree and resolve the entire matter, both complaints, rather than separating them out and going to hearing on one matter and then clearly from that point going to litigation.
I clearly understand that hard facts make bad law on occasion. These facts were not terribly complicated and presented a pretty clear constitutional issue. Who, in your mind, is the appropriate person to bring that issue to completion?
I think the commission and council as part of, I don't know that letter, for example, I don't know whether it has or not, has ever been fully evaluated by county council and reported back to the commission and to the board of supervisors.
The impression I got was that county council didn't feel that that was his position, that this, like any other litigation, depends upon the litigants to clarify the issue to the trier of fact.
I think the county council, and I don't mean to put words in county council's mouth, I think the county council felt that it wasn't county council's position at that time with a pending matter. And that was the reason we discussed coming to a resolution of the entire matter so that then the issues raised could be evaluated in a vacuum, essentially, and not in the course of an enforcement proceeding.
I didn't mean to hijack the discussion.
I would just raise one more point of information for the commission. I favor the rules relating to timing, the procedures related to timing. I think that's a great improvement, and it helps me when I deal with respondents. I will say, though, that not every respondent is going to be cooperative in those rules. We're going to find respondents that are not, and that timing may force us into, on rare occasions. So far, I found most respondents to be very cooperative. On rare occasions, that timing may force us into a hearing that is probably unnecessary if we had a little more time to kind of
Do you
work
have
it out
a
a little bit.
suggestion?
I don't. If the commission's concern is timeliness, I think that it's the commission's role and ultimately the board of supervisors' role as the legislative body here to decide what's timely and what's not. And if you look at the Political Reform Act and you look at the guidelines that the FPPC follows, 2 years, 3 years is not untimely to them. There's a 4-year statute of limitations. Stuff takes forever. The city of Los Angeles moves a little faster, but it's still not anywhere near as fast as what you're proposing. You have to decide for Ventura County what's timely, how quickly do we need to move these things through. I will point out, most of these violations are not serious violations. They're not the kinds of things that the supervisor was referring to. If you had some nameless PAC come to town and dump $100,000 into an election without any kind of reporting, there are mechanisms to move quickly on something like that, as the FPPC did. Most of the violations that I have dealt with are, in my view of the world, relatively minor violations they've all been first violations, and that's explained the fine level as much as anything else, but it also impacts the timing.
Mr. Johnson? Well, that's kind of my point, that they are minor. And I'm wondering, I'm obviously not a lawyer, and I may be way off base here, but it seems like, to take a step back in time and say, let's talk about, and this may not be the right forum for this, and maybe this should be before the Board of Supervisors, because they are the legislative branch. I saw the role of this commission as simply hearing the reports and making a determination as to, whether we felt a violation was committed and whether or not the resolution was suitable, but not, sort of going to court. The judges are at least not supposed to be writing the laws. They administer the laws and rules of court as they have been set down by someone else. So going back to step one, what is the good? What is the benefit in light of how things have changed so dramatically with the Supreme Court's decision on Citizens United? This isn't directed at, I guess it's more just the supervisor, but Supervisor Bennett, when you said that you discovered a week or two before the end of the election that some money got dumped into the campaign, was that the result of this ordinance and this commission, or did that become known and therefore became public knowledge and changed the limits on what one could spend? It just seems like there is a possibility when, going back, like, this is not just a 2-year-old ordinance. It's, I know it keeps being revised, but it goes back, about 10 years maybe? How long, when was the thing?
8 years.
Okay, so 8 years ago, and one of the concerns, and I remember as a citizen thinking, boy, we need to do something, and this is sure a good step in that direction, again, pre-Citizens United, that somebody can just come into our county and dump a lot of money the night before and put out a hit piece with no time for candidates to respond and distort the process. But it seems like there is greater opportunity to do that now, and almost no effect on the part of this commission on those kinds of things, which I would consider to be the really significant issues as opposed to the technical violations.
Well, I guess it's good that we're having this discussion now rather than 3 or 4 weeks ago, because I would offer to you a few things. We have in our county a limit on how much money people can give to candidates right now. Citizens United, that's one of the few things Citizens United did not take away from us, is that ability to do that. That by itself already, I would say that's not minor, that's major. We had an individual in our county give $90,000 to a Board of Supervisors candidate before our ordinance was passed. So does having the ordinance have an impact? Absolutely. $90,000 versus $700 contributions to a
But don't they give that $90,000 now to a super PAC?
They could give that $90,000 to a super PAC. So I appreciate what you're saying. In light of Citizens United, it doesn't have an impact. But it is much harder to have the same direct impact and coordinate that expenditure of that $90,000. If they could give that $90,000 directly to the candidate and do it early, legally, like had happened before our ordinance was passed, that changes the ability, almost the effectiveness of that $90,000, because it can now be coordinated completely with the candidate's campaign. And I think in spite of all the efforts that there is no coordination between independent expenditure committees, but it is more difficult for them to go through the coordination process at least. So you already have that impact because the existence of this ordinance and this commission, and I might point out, without the existence of this commission, you would not have an ordinance that would be effective. You have to have this part of the process, and I'll explain that in just a second. But you would not have a $700 contribution limit that would be effective out there if that wasn't the case. So that's not minor. So it's hard to, I think, for you to necessarily sit there and feel that. But I would offer to you even more specifically, this was how it happened before. That mailer would have hit about 3 weeks before the election. The candidate, myself in that situation, would have started scratching my head trying to figure out who was paying for this mailer. I would have filed some complaint with the Fair Political Practices Commission if you did not exist. And that Fair Political Practices Commission, everybody would know that one of two things would happen. It would be a long time before they ever even responded to the complaint. Many times complaints were filed and people said that they never even got responded to by the Fair Political Practice Commission. But it was like literally for local candidates, Fair Political Practice Commission was not prioritizing and would not be prioritizing any kind of action 3 weeks before the election here. In fact, because this ordinance exists and because we're having this hearing now, I think it's more likely that if we get to the next election and it's 3 weeks before the election and somebody dumps a lot of money in, not only will they feel a little bit of pressure because they're going to get notified, there's an apparent violation of our ordinance, but I believe we can actually improve our ordinance so that they'll get notified, and if they don't reveal within X amount of time, for example, the 3 largest donors to their PAC, right? If they don't reveal who those 3 largest donors are, and we may be able to write into the ordinance even more things. You won't get that kind of disclosure if we rely on the Fair Political Practice Commission. So in this election, I don't believe when you see the complaints come forward on this election that you will call them minor. I believe you will see a pattern, a very concerted pattern of filing in such a misleading way, in such a way that where they were continuing to hide the information while they were filing, that you will say these are not minor matters. This was a pattern of trying to hold off as long as possible, letting the other candidate know how much was being spent. And if you could do that, you could disadvantage that candidate so that that candidate would not be able to go over the spending limits and therefore not be able to respond to the attack mailers that were being sent out against that candidate. Now, being somebody who's just gone through that process, I don't call that minor at all. If one mailer can go out there that's an attack mailer and the candidate is now disadvantaged because they're at their spending limit and can't respond to it, and they're able to hide that information long enough, the post office, I will offer to you, informed all candidates that the Tuesday before the election, 7 days before the election, was the last day the post office would accept mail, political mail, and guarantee it would be delivered by the Tuesday before the election. Now, that's a first for the post office to do that, but because of cutbacks at the post office, etc. But look at what that does to the election cycle. If you can block a candidate until about 10 days before the election, you can effectively disadvantage that candidate to respond.
Okay, and that did happen this time,
That
right?
did happen.
Okay, and how did that come to light?
It came to light because their mailing came in the mail. And I was able to go to elections and go, what is the information? And we were able to start to unravel who...
With or without this group in the ordinance, would you not have had that same information?
No,
You would not.
I would not have had.
It would have come in the mail, though, wouldn't it?
It came in the mail, but I would have had to rely on the Secretary of State to be able to go and get this information and find that out. I would offer you another thing. Our ordinance says if you spend more than $10,000, you have to file electronically. You know, somebody that lives in Simi Valley should not have to drive up here. And there is right now in the clerk's office a whole file that's oftentimes not in accurate alphabetical order because the public goes through it all day long.
But is all what we're talking about money that would be contributed directly to a candidate as opposed to...
No, this is money contributed to a PAC spent on an election in Ventura County. Because of our ordinance, they had to file here in Ventura County. And they were supposed to file electronically because they had spent more than $10,000. Now, they failed to do that Because look what would have happened. If they would have filed electronically, it would have been easier for somebody to find that filing out and be able to then respond. If we didn't have our ordinance, they would not have had to file electronically.
Excuse me, sir.
And it would have been even longer for the candidate to figure out whether they filed. And they could easily have said, you know what, we're not going to file with the state. It's only a $10 a day penalty. At least that's how it used to be, and I don't know today what it is. But if they didn't file with the state, the one thing you could be pretty certain is the people involved in this independent expenditure PAC, I don't think would feel very much pressure that there would be some kind of action. I think they feel there's a greater likelihood of significant action coming from here in Ventura County. And again, if they wouldn't have filed locally, it would have taken more days, maybe more weeks to figure that out, and we were literally right up to the deadline. So it would have made a difference. If they would have filed electronically, it would have made a difference. I would offer to you one other thing that is difficult. With a candidate, you can hold the candidate financially responsible for the action of the candidate. With independent expenditure committees, it's not clear to me who you hold legally responsible for not complying. But that is one of the things we're going to try to beef up and make more clear in our ordinance, so that there is a sense of, hey, I'm going to say it this way. You know, urban sprawl in Ventura County, urban sprawl in Southern California was something that the vast majority of citizens really had a frustration with. But if you talk to most citizens, they scratched their head and said, but we don't know what to do about it. You know, these guys are going to get their projects through. It'll be piecemeal. And most people were frustrated and unhappy. And yet, even though the vast majority of citizens didn't want the urban sprawl that we got that urban sprawl. In Ventura County, we came up with a SOAR initiative. And I think the vast majority of people are supportive and also proud of the fact that we've come up with a solution. I would offer that with this commission and with this ordinance, if we do it right, we can get to the point where people can say, hey, if you want to play in politics in Ventura County, if you want to get involved, if you want to dump $100,000 into the election, then you know you're going to have to play differently than in the rest of California. You're going to have to be squeakier clean. The public is going to know who is spending this money. And they're going to know promptly, because we have, working together, sort of evolved that kind of process. I believe that's where we are in the process at this point in time. And the final thing I would offer to you is, only this commission, only the three of you have an ability to do some things that none of the rest of us can do. Actions by the Board of Supervisors are oftentimes going to be painted as politically motivated, as being self-interest motivated, rather than trying to come up with what I just described, which is, I think, just like we have SOAR, it would be great if Ventura County could be known as just one of the cleanest counties in the state of California, and maybe in the country, in terms of election reform and what you have to do if you want to play here. But only you have the ability to ask the questions and say, you know, are the settlements that Mr. Steele coming up with, are they appropriate? Are they sending the right messages? Only you have the ability to say, we think the process isn't working properly. We think either there's a glitch in the way the CEO's office is handling it, there's a glitch that you are at least exploring, which is there's an unresolved issue here that Mr. Steele is settling and saying we agree to disagree, and now you're questioning, so how's that get resolved? I mean, where do we go here? Mr. Steele is saying it's up to our county council, but if you aren't the ones that ask those questions, if you aren't the ones that make recommendations for changes, everybody else is going to be hamstrung in the process. There's the possibility the county council is going to say, you know, we work for the Board of Supervisors. We're not going to touch this. You know, we're not going to come and make more recommendations. There's going to be a possibility that Mr. Steele is going to say, well, my job was to get this thing resolved. It's your guys' job, or the commission's, or the Board of Supervisors, somebody else's job to get this issue resolved that is out there. Or the CEO's office may go, you know, we're going to just keep spending more money that, you know, we don't care. We just want to spend the money to make sure our tracks are covered, and whether it's done efficiently or not. I just want to point out that nobody's doing anything wrong in any of those situations, but only you have a credibility, a perception of independence, a perception of all kinds of things that can be something that is very valuable to take this ordinance to where we want it to go, and recognize that it's not there at this point in time. Thank you for your question. I'm happy to.
I have another speaker card, but I think before I get to that, with the concurrence of the commission, I'd like to call on Jim Becker.
Don.
Jim Becker.
Oh, Jim? Okay, good.
It was advised that
The
I
Becker
have your
boys.
card.
Sorry, Jim.
By way of introduction, Commissioner Johnson had some questions about reports of violation and complaints, and maybe you could express your concerns there.
Maybe the last
Yeah.
meeting. Well, my only question is what was I was missing some of the subtlety on the idea of an apparent violation versus a complaint. And there was some discussion, including members of the audience, that in some ways an apparent violation filed by the official elections office seemed to carry in many ways more weight than a complaint from a partisan involved in the battle. And I don't know that my question, how much significance it has, but I was just curious as to why we made that distinction instead of either it's a complaint or it's not a complaint. Both of them have to be, I presume, looked at in the same fashion by whoever investigates. And maybe I'm wrong on that.
Well, it is a significant question, Mr. Johnson. I appreciate that. First of all, I am Jim Becker, and this is Don Becker, and we're frequently confused. But Don was my former neighbor, but we're not related, just for the record. And I'm here today on behalf of Mark Lund. Mark had a family emergency the last couple of days this week, so he wanted to be here but is unable to. To get to your question, and first of all, we don't really have a prepared statement today for you. Really what I wanted to do is address your questions. I do have some comments, if you'd like, I can make, and then answer any questions. The real brains here is Tracy Saucedo. She's hiding in the back there where I was. And Tracy can talk to you about some of the technical things as to which reports are filed, what we do with the reports when they're filed, and that nature. But I'm kind of here to talk to you about this question and some sort of general policy things. Elections, let me just set a little background to answer your question. The way we view this ordinance is, number one, we see our main role as a neutral party. Our job, we feel, is to conduct a fair and impartial election. We do that under law, and the main law that we go by is the Elections Code, some government code sections, and then in this case, the Campaign Finance Reform Ordinance. So just as we interpret the Elections Code, interpret's the wrong word, just as we read the Elections Code, we do the same thing with this ordinance, Mr. Johnson. We'll look at it, and we basically read it literally, because it's not a lengthy ordinance. There are some ambiguities in it. It doesn't cover everything. It's because any ordinance that's written is not going to cover all the nuts and bolts of what you have to do on a daily basis. So when it comes to whether we make a report or a complaint, we kind of refer to the ordinance. And what we read is in section 1298, it spells out the duties of the county clerk. And it says the clerk shall. So when we read shall, that's not discretionary to us. It says we shall make reports of apparent violations. Now, there's also the complaint that's referenced in the ordinance, and I think that's under 1297, where that's written in more of a discretionary tone. It says the county clerk, I think, and citizens may make complaints. So again, reading the ordinance literally, not trying to interpret our position, we say that we have a duty to make a report, and we have a discretionary option to make a complaint. So with that, we go with what the duty is. The other thing, and I've read this ordinance more closely since the last time you met as far as that particular question, because Tracy advised me that was one of your concerns. When I look at section 1297, and I may be misinterpreting this, so clarify if you need to, but it seems like when it gets down to it, even if we make a report of an apparent violation, once it goes to the CEO's office and then starts the chain through the review attorney and the investigating attorney and eventually to you, it's bundled, I think it even has some language in there, that the apparent violations are kind of bundled into a complaint. So it sort of is considered a complaint. So to us, we're a little confused, and I guess we'd like some clarification too as to really the distinction between a complaint and an apparent violation. We use the... Go
Can I
ahead.
ask you just one question? Has the Elections Office ever filed a complaint as opposed to an apparent violation?
Not in the time I've been there. I'm not sure. Tracy, do you recall?
Yeah,
We
I
can-
mean,
we can
it
get that
sounds a little bit
information
like,
for
you know,
you.
the state legislature having
Yeah.
a referendum as opposed to an initiative, you know, as to where the thing starts, but in the end, once it's on the ballot,
Yeah,
Yeah.
I'm not aware of it. The other main reason that we use the report format as opposed to the complaint kind of goes to, I think, Mr. Steele's comment. He used the term, I'm going to borrow it for this, politicized. What we feel, and I understand, I wasn't here, so if I'm misstating what you said, jump right in. But I can understand that maybe some people in the public might say, okay, well, you know, you have citizens or you have the elections division that can file these complaints. If a citizen files a complaint, some people may say, okay, well, this citizen's aligned with one candidate or the other. So they just got some sort of like self-centered interest here, and you know, they're just putting a smoke screen on it, and this is really their true motivation. If the elections division, who's, you know, the official conductor of the elections, files it, it must be serious. It must be something that's significant. Some people are going to think that, I agree with you. But the problem with that is going back to our core mission, which is to remain neutral and conduct a fair and impartial election. If we jump in and use our discretion and call that a complaint, it does possibly take on that significance. And what we may do inadvertently, and we don't want to do, is we do not want to get in between the candidates. Okay, we want to conduct the election. We want to give them the forms. We want to make sure they're doing everything by law, but we don't want to take sides. So if in a particular election, and this one there were several reports, in prior elections there hadn't been, but let's say most of the reports are against one candidate, or the committees that basically are for that candidate, and the other candidate doesn't really have them. Well, if we start filing complaints, it sort of looks in a way that we're sort of taking sides. We're not taking sides. We don't want to take sides, and it doesn't say we are. But that same public perception that could say, you know, it's more important and significant if you do it, might also conclude that somehow elections is making a political statement about one candidate or the other. And to us, you know, the significance of that is huge. And so we want to take the lowest key approach, because in the end, your commission, if it goes through the different attorneys, will get the same information. So whether we call it a complaint or a report in the beginning, ultimately, in my view, it doesn't really impact the information you receive. So.
right, and I didn't interpret it that it would be, we would get different information, but, you know, it's sort of, if words have meaning, and I understand the nuance there of attempting not to, you know, what do they say in basketball or in any sports activity? Let the players play the game. You know, the refs should back off. And when as it moves up, you know, if you've ever had to be a ref, you know, sometimes, well, okay, I let one slip at that end. I guess I better not be too hard on the other end. You know, to try and remain neutral. I mean, that's a dilemma that's always going to be the referee's problem. I was just curious as to, I guess the first question is why the elections would be drawn into filing apparent violations, and I assume that's because they're standing at the gate where everything, you know, the crossroads where everything comes through. But as soon as you do that, that puts you folks in that boat. And so I guess maybe I was getting educated in a clumsy way here, that there really isn't a distinction. It's just the amount of responsibility or. Well, it just depends on how sophisticated the voters are as to how they interpret this,
Right.
because I now realize they're one and the same once it gets put into the system. It may have a different marketing or a public
The
relations.
reason to answer, or it wasn't a question, but the reason we get drawn into filing a complaint or a report is the ordinance tells us to. I mean, that's basically why we do it. It says, if you see an apparent violation, and again, there's no definition of apparent in this ordinance. There's no definition of report or complaint in this ordinance either. So we take the kind of the commonly held definition of apparent, meaning it appears to be. So if we think it appears to be a violation and the ordinance directs us, says you shall do it, then we're going to do it. So,
Any other questions of Mr. Becker?
Yes, if you, on the process that you use, if you see an apparent violation, whatever that is, and I assume that most of the time you see that on the documents or the record, something hasn't been filed or something, do you do any investigation? Do you pick up the phone and call, or do you look into it, or do you simply say, this wasn't done in a timely manner, therefore we're going to report it?
I believe we do contact the party that has filed the particular report. And there's also, Mr. McBride, there's also an internal process. We have somebody, a supervisor in elections that basically oversees the campaign finance ordinance and the filing of reports. And that's the individual that usually first sort of sees the apparent violation. And that violation is discussed with Tracy and then with myself, sometimes with Mr. Lunn. And so there's a decision made. We don't just jump and say, oh, here's a piece of paper, bingo, let's write up another report so we can add to the stack. We look at it internally and kind of do our own internal review. However, we kind of stop at the point of doing a really full investigation, because it's different from, like, if we had a situation where we felt that somebody was not registered properly and we had to make the decision to take that person off the registration rolls. That's a serious matter too, and we would do our own internal investigation and make that decision. We've done that in the past. In this case, because there's already a process set up with, you have a reviewing and an investigating attorney, you have yourselves, we don't feel that doing a thorough investigation ourselves, we're not a party to that. We already have a process to do that. So we do sort of a preliminary. If it meets the appears to be test, then we'll send it to the CEO from that point.
Thank you.
Thank you.
Sure.
Mr. Becker. Don Becker.
Good morning, Mr. Chairman and members of the Commission. Thank you for giving me a chance here. You've been doing you've heard from several people, and there's been a lot of discussion at a high level. Mine is at a much lower level. And I understand what Mr. Steele said about politicizing the process and therefore not trying to get things completed within the election cycle. But nevertheless, it seems to me, as I said before, that the people that are going to vote do have an interest in whether or not the candidates are playing fair. And so they have an interest in having some understanding of what's happening with these complaints and the apparent violations. And so I would make one suggestion for your consideration. And that is, as far as the initial review is concerned, it's hard for me to understand why 30 days is needed. It seems to me that the initial review should be able to get done in a lot quicker fashion than that. I mean, after all, it's only whether or not, if the facts alleged are true, would it constitute a violation. So we're just... Here's an allegation. If it were true, is it a violation? If not, then it's not a violation. If it is a violation, then we send it off to the investigating attorney. So it just seems to me that should be able to be done in a more timely fashion.
Thank you.
Thank you.
Mr. Norman, would you care to respond to that?
Yes. It is true that there's some duplication of effort on the part of the initial complaint review attorney, speaking for myself, and the investigating attorney. But I think that's inherent in the process. If there's a complaint or a report of a violation, and incidentally, from my standpoint, a report is a complaint. I treat both the same. And For example, it may result from the Form 460, which says there was a contribution of $7,000. And by an initial contact, it was determined that the contribution was actually $700. It was a typographical error. Those things do happen. In the recent election cycle, the reports and complaints that I have reviewed involved more often than not this Form 1275, which has to be completed and filed by a committee reporting any expenditure in excess of $1,000 for a particular candidate or opposing a candidate. So at least I see my job as to make an initial inquiry as to was the report actually filed, and if it was filed late, why? Was it due to someone sending it to the wrong address or what? So I think there's some initial facts that have to be developed before I submit my report. Sometimes that evolves into a process which I don't particularly or didn't anticipate and don't invite, but I mean there's a lot of back and forth between the complainant, between me and the respondent. So in those instances, I take the full 30 days to try to resolve it before it goes on to the investigating attorney. If the role of the initial complaint attorney, review attorney, is merely to review the allegations of the complaint without more and determine if those allegations standing alone constitute a violation, then I think the 30-day period does not have to be 30 days. But I believe there's a necessity for some screening process up front. And I don't think the 30-day period is particularly unreasonable. I do see with this last go-around some issue with this Form 1275. I think it's a very important form, and it should be filed timely. But I'm not sure that the committees involved for or against candidates are really aware of the necessity of that other than by reading the ordinance. I don't know what goes on when a committee is formed, if they file a registration of any kind, and if so, do they get all the required forms that they are required to file, or are they left on their own to determine when and what is required to be filed? That form, 1275, in some instances, the necessity for it is not determined until the Form 460 is filed, which is on a monthly basis, I understand it, so it should be far beyond the 24-hour period. So my only reaction to what has occurred in this last election cycle is that what more can be done to put the committees on notice that this form is needed and must be filed promptly within the 24-hour period. And if it's not formed, I think they're filed, then there should be some consequences unless there's some excuse for not filing it timely, namely that the office was closed or they arrived at 5:05 p.m. and they filed it the next day, that sort of thing. So to answer the question that was just recently raised, I think that in many instances it will need the full 30 days. In other instances, not. But there has to be some initial inquiry, I think, to avoid the necessity of an investigation if, for example, there was a typographical error on the form, or if, for example, the report was filed one day late because the person didn't get to the office on time or didn't electronically file it. So I don't know if that answers the question or not, but
my initial impression of your job was essentially as somebody treating the matter as a demurrer. Is the complaint sufficient on its face?
Right.
Is the state facts, which if proven true, would constitute a cause of action, a valid complaint? But that's not the way our ordinance is written. Under 1295D, the initial complaint attorney shall review complaints, evidence submitted with the complaints, and evidence submitted by the alleged violator, and issue to the commissioner a written opinion within 30 days about whether or not it's sufficient.
right.
So our ordinance, unless amended, envisions something more than testing the legal sufficiency of the complaint or reported violation as it comes to you.
I agree.
Okay. Thank you.
All right, thank you.
Do you have anything further you want to?
No? Thank you.
So would that possibly be an area for the evolutionary improvement of this, that since there are two attorneys involved, that it's not necessary. I assumed, I don't know if this is proper legal terminology, but I assumed the conflict of interest or the potential for self-referrals if one attorney is both evaluating whether this needs to be investigated and then proceeds to investigate it and bill for the investigation. So now they have two attorneys doing that, and so maybe the clarification in this area might be beneficial.
Makes sense to me. Do we want to hear from Supervisor Bennett?
I realize when you have a public hearing and you close the public hearing, when you have a study session, there's probably some benefit in terms of going back and forth. If I could point a few things out. The language that you just referred to in terms of what the role is of the investigating attorney was an attempt to try to come up with some kind of compromise to protect the use of taxpayers' dollars because of complaints about, hey, taxpayer dollars. So let's say, well, we have this situation. A report was filed where somebody had made a $7,000 contribution. In fact, it was a typing error, and it was a $700 contribution, and they hit an extra zero. Do we want that? If you take the language, the facts, if they are true, requires a investigation. You know, it's a fair question. Do we want the initial review attorney to say, this one should not go any further, this one shouldn't take any more taxpayer money? Or, no, this one should go on and be investigated a second time and have the investigating attorney hear the exact same information, which was it was a typing error, and particularly if they fixed it immediately. In other words, they were informed and they filed an amended return and did that. Now, I'm not sure that this fix has happened because then everybody knows. Right now, we still, at least from my perspective, we're still scratching our heads. Was that a typing? This is the first I've heard it was a typing error. So, you know, was it a typing error? Was it not a typing error? You know, that would be good for everybody to know. If there's prompt disclosure of that kind of information, that would be helpful. If there was an amendment that was filed. So that's the reason why the language is as it is, and so it's not as easy as we think to just say, hey, if the facts as alleged are true, because somebody could say, hey, I allege that candidate X just took $10,000. Well, if we leave that very narrow thing, well, if that statement is true, then, you know, but if there is absolutely not a scrap of evidence, and we know we have some people that would be willing to file complaints with no evidence at all, if there's not a scrap of evidence that this candidate has taken $10,000, then should this go forward? That's the dilemma that we find ourselves in and why we have an investigating attorney doing that. So that's one area I'd like to comment on. The second area that I think is important to comment on is some comments that we just heard from Mr. Jim Becker, not Don Becker, right, in terms of the clerk wanting to stay neutral. Certainly, we don't want a perception that the clerk is not staying neutral, but that is not the overriding responsibility of the clerk. The responsibility of the clerk is to follow the law. And I would take the referee. The referee does not sit there at the end of the game and say, did I call just as many fouls against one team as the other team? No, the real measure is, did I call the fouls that I saw that should have been called? If one team wants to camp out in the 3-second zone every time they go down, the referee can't say, we just heard that statement, if we filed, you know, many reports against one candidate and none against the other, that would have a perception of being unfair. Well, if one candidate consistently doesn't file their report or consistently does something that is an obvious violation just on its face, I believe the clerk should not have the responsibility, and that is why it says the clerk shall file. The clerk should not be saying, well, we want to keep this perception, because that now is a perception of unfairness the other way. That's a perception that the clerk is actually not willing to do what the ordinance says the clerk should be doing, because the clerk favors the other side of it. The clerk, those should be blinders in terms of how many things are filed, etc. And you're exactly right, Mr. Johnson. It is because, and I'll give you a classic example of my situation. This committee, Independent Expenditure Committee, filed with the clerk in mid-September that they had formed and had spent more than $1,000. Right? Now, the ordinance says within 24 hours, the opposing candidates, or all candidates in the race, should be informed of that. Now, that is the role of the clerk, to be a chief informer. That's fairness, right? The clerk did not do that. And the clerk is supposed to do that within 24 hours. And I think we understand why there's a 24-hour rule there. A candidate should have the right to know an independent expenditure committee has been formed so that they can begin the process of monitoring that. Without that information, there is almost no way that a candidate would know this independent expenditure committee could be formed, because they could go under any name. They could go under Zebras for, good Ventura County government. And you would have to look through A's, B's, C's, D's.
How long did it take them to notify everybody?
The clerk?
Yeah.
The clerk did not notify me until I went to the clerk and informed.
So it wasn't like it was 72 hours instead of 24.
This
They
was
just didn't do it. Okay.
a month later, all right, when I went. The clerk simply did not do that. The clerk was then, another report was filed on October 5th. Again, no notification to me as a candidate. It was not until the mailer was received. Now, again, if you know the clerk is not going to do their job and inform, I would offer the fair question that could be asked is, if the tables were turned and it was a different candidate, would that candidate have been informed of this, right? We shouldn't have to ask that question. And the question in the clerk's office shouldn't be, are we going to do this or not? It is perfectly fine for there to be a chain of command. In fact, there should be. There's one person in charge, and that's the clerk. There should be a chain of command. But the clerk's position should be, if the law says...
I get your point. The reason my question was just simply, is this the 7,000 versus 700 typo, as is 48 hours instead of 24, and you're saying, no, this is more deliberate or at least more neglectful because it didn't happen at all.
Right. And so I just don't want to leave us with, or have you believe that what the role here is to appear neutral. The way to appear neutral is to follow the rules. And if there are 5 apparent violations, if things are not being filed, and they're supposed to be filed, certainly the statement shouldn't be, we don't have time to do that. Certainly the statement shouldn't be, that's not our policy to require that. The ordinance should identify for you what those policies are. So those are the two things I would offer. And again, this is the evolutionary process. So I welcome, and I'm just, in hearing this discussion, it's good for me to be here and hearing this discussion, trying to craft what is the right language that protects us from expending the taxpayer dollars on initial investigation, and at the same time preserve sort of the objectivity of of this. So I welcome your input on that. Thank you.
Thank you. Jim Becker? Don Becker.
Raise your hand. Go ahead.
Thank you. I just want to clarify my comments because I think the last speaker kind of was mixing apples and oranges here. The comment I made about not wanting to politicize the process was in response to the question of whether we file a complaint or a report. And I'm hoping if I didn't make that clear, I'm clarifying that now to you. I started off my comments, and I want to restate that our number one job, based on following the election code, the government code, the campaign finance reform ordinance, or whatever law governs us, is to conduct a fair and impartial election. It's always based on the laws that regulate and govern us, and that's what we do. I'm not going to comment on any of the other issues because those are actually, as I understand it, part of a complaint that's going through the process. We just received last night, and I don't think, for myself, it's appropriate to comment on that at this point. But if you have any specific questions, feel free to ask.
I was hoping that it didn't relate to any pending matter. Thank you for your comments.
Okay, thank you.
Don?
Well, I'll defer to the gentleman.
Okay. Mr. Norman?
Yes, just a point of clarification, and I have not read the ordinance word by word on every section, but in regard to this report form that I mentioned, Mr. Bennett suggested that the clerk did not notify him within 24 hours that the report had not been filed. I thought that's what I heard him say. Under the ordinance, the clerk has a duty to notify the other candidate within 24 hours of receiving the report, that the report has been filed. But if, for example, a committee makes an expenditure of $2,500 early in the month of a calendar month and files no report, I don't know that there's a method whereby the clerk would know that that report was required and had not been filed, at least not until the Form 460 has been filed, which lists all expenditures. At that point, yes. So this idea of the report, it really, the burden is on the committee to bring the matter forward. And that's where I would hope, and I'd love to see some means of enforcement on these committees to get them to recognize the necessity of this Form 1275 report and of their obligation to file it within 24 hours of an expenditure in excess of $1,000.
Thank you. Do you still have something? No?
Yes, I was just waiting to see if Supervisor Bennett had any follow-up on that.
I'm trying to hear the complaint. I'm trying to contribute to this.
Again, I'm at a much lower level than all these other discussions, but as far as the initial review is concerned and the desire to make sure that we're not increasing the amount of money that the taxpayer is going to have to expend, it seems to me that there's an argument that if the initial reviewer does an investigation, of even a preliminary investigation, and then they pass it on to the investigating attorney, that person is going to do another investigation, so there's going to be duplication there. And so the question is, how valuable is it for the reviewing attorney to actually be tracking people down and asking and getting responses? After all, when you file a complaint, you have to put in what the complaint is, what the problem is, then you have to offer proof. It seems to me that the initial review should be to look at that complaint, to look at the proof, and to see, is there proof? Is there anything that on its face value makes sense? If so, then you send it on to the attorney. Now, if it turns out it's merely a decimal point incorrection or incorrectly placed, then the investigating attorney is going to find that out fairly quickly, him or herself, and so you're not going to have a long investigation there either. But it seems to me, again, from my perspective, that the public has a right to get an understanding of what's happening with the various candidates. And so anything that can be done that would help some kind of initial report, something that might be picked up by the newspapers and might be put out there, even though it might politicize the process a little bit. I mean, the fact is, I, as a citizen and a voter, I want to know. I don't want to wait. I know that going through the entire process, there's no way you're going to get it done within the election cycle. But at least that initial review could be done within the election cycle.
Thank you. All right. In the absence of any other speakers, we'll close the public or the work study hearing. I guess we have several questions to address in connection with finalizing that matter. One is, we heard some considerable discussion about the time limit for referring the matter to the commission after the investigating attorney has completed his work. He has 60 days in which to file a report in the event that he determines that there is no violation, and thereafter, if there is no resolution with the complaining party or the respondent, he refers the matter to the commission. Is there any sense that we ought to put a time limit on the amount of time after the 60 days during which the investigating attorney should refer the matter to the commission and schedule a hearing? Well, I'm not talking about the 30 and 60 days. I'm talking about the amount of time after presumably negotiations have been undertaken unsuccessfully, and the obligation at that point in time of the investigating attorney is to refer the matter to the commission and set for a hearing. That has been delayed significantly from that 90-day deadline. Do we want to put, or do we want to suggest that the board consider putting a limitation on that?
That can be an issue of simply staff scheduling. I mean, you can put it in the ordinance, but also I think, let me back up just a little bit. The ordinance provides 60 days for the investigating attorney to resolve the matter, or if it's not resolved at that time, to inform the commission that it's not resolved. Is that correct? And that 60 days seems reasonable. Then the question is, if it is either not resolved or if it is resolved, either way, it needs to come to the commission to be finalized. And there should either be a formal or an informal process of getting that to the commission as quickly as possible. Now, some of that is our own schedule. How do you schedule meetings and things like that?
Right.
I don't know if that should be in the ordinance, but I would think that we should be meeting on those within 30 days.
It appears to me that the appropriate place to make those changes is in 1296D of the ordinance, but then we'd have to amend the rules and procedures, operating policies, specifically section 1304, but there may be other changes that are required. Do I have a sense that there's a desire that we inform the Board of Supervisors we would like to see a 30-day limitation placed on referral to the commission after no resolution?
Well, my preference is, rather than look to amend the ordinance, is direction to staff that we have, at the end of that 60 days, that the hearing be set within 30 days, and that's our internal procedure, that's what we do. If that doesn't work, then I think we move to, codify.
I agree, and we would second that if that's a motion. I think just should be the guideline. There should be an expectation that it's taken care of in 30 days unless there's a really good reason for it not being.
Right.
So I presume we can simply address that as directions to staff. There's no need for a motion.
Okay.
Okay. Second issue that we discussed and was discussed in the work study session is the way that reports of violation are handled as opposed to complaints. Speaking for myself alone, I'm satisfied that that process is working well and that the criteria utilized by the election division in deciding whether or not to file a report of violation is both consistent with the ordinance and good practice. Is there any contrary feeling?
I can't come up with another process, so I think it...
I think it's sort of a distinction without a huge difference, and I was just looking for clarity as to why it was coming that way. I don't have any problem with the way it goes. The underlying thing seems to be more important. That is, if somebody files a report and they fill the report out incorrectly, how much time and effort are we going to put into trying to protect them against themselves for having committed the error? That's part of the defense as to I didn't mean to do it, or it was not factual, but it is factual that the report got filed and somebody said 7,000 instead of 700. Shame on them. It's going to be inconvenient if they do that. Doesn't mean there'll be a big fine if it turns out that somebody just typed it wrong, but it shouldn't be, I don't think, a reason to delay the process or have, legal, billable hours calling people up to say, did you really mean that? It's going to have to be done one time as just part of the investigation. So it just seems like on the surface of some of this, we can look at it and say, this is complicated, this needs more information, but a lot of times Did it come in on time? No, it didn't. That's a violation. Did it exceed $700? That's a violation. It may turn out that there are reasons for this, and the fines will be minor, but so far the fines have been minor anyway, if not non-existent. So it just seems like have been caught up in so much process that the purpose is sort of getting lost.
But what's the alternative? I mean, at some point, either you have a hearing and you have the parties come in and say, gee, I made a mistake.
Well, I'm thinking that we have two investigators. The first one simply is looking at on the face of this, is this have the basis for a complaint, and kick it over. Then there's one phone call made to say, is this a decimal point error? Rather than, I don't know, but maybe that doesn't speed anything up, but it just...
We've used the process of sending a warning letter in the past. I noticed one of the dispositions so reflects. Maybe that's the easiest way to handle something like this.
Well, it seems to me that's part of our dilemma. That it's sort of like telling a child, "Now, please don't do that." Now, I thought I told you not to do that. Now, I really mean I don't want you to do that. At some point, blah blah blah. No one listens. It just seems like the responsibilities for filing a report or announcing that you're a committee or whatever. It is the law. Now, there may be wonderful extenuating circumstances that would say, I'm not really a bad actor and it will never happen again, and that would be taken into consideration. But the fact is, if they didn't do it, why do we, is there some way we can tighten the process up a little bit with regard to, warning letters or investigations? It just seems... If this has basic value, and I in another conversation, I'll meet with Supervisor Bennett to understand all of the nuances in a campaign of how this kind of keeps people, at least slows them down from kind of bushwhacking each other in the process.
Somebody's going to investigate the validity of the complaint. And right now, we've split that a little bit between the two attorneys. I think that's not a bad compromise. We have the investigating attorney taking a quick look. Maybe some of this could be done, if you had an administrative body, or if you had an office that did it, they could be done by almost anyone, some of this. But we've decided to split it, and we have the investigative attorney taking a quick look at it, saying, the facts aren't as alleged in the complaint. They're obvious. No violation. I think that's a decent compromise, rather than to simply have the investigating attorney look at it on its face. And I know, that's what Don would like, but rather than have him look at it on his face and say, yeah, that's a violation, I think that can lead to more complaints, not based in fact, which can have really a negative impact on the election. People can come in, they can file complaints, they can put their facts in, the facts aren't complete, they're one-sided, and you go off with this violation, and it's really, one phone call would have cleared it all up. So I think the way we have it, as imperfect as it is, I think it works.
It doesn't seem to have provided a great problem yet.
Yeah.
All right.
It all, I'm not to be argumentative, but it all gets down to what is quick. I agree. If it's quick, then it doesn't make any difference how we do it. But if it requires in-basket delay and phone calls back and forth rather than just simply moving it, I would have the same confidence in either investigator.
Right.
But it's the length of time it takes to get there. And I agree that if somebody makes up a story and there's no evidence of that story, then it obviously requires that there be more investigation on the front end rather than allow those to keep going all the way through. But in some cases, it seems like the office of the clerk of the county could say, did it get stamped in on time, or did it come in on the computer on time, or whatever. Those are pretty just hard and fast. Just move them as quickly as possible is my suggestion.
All right, well, I'm not hearing that there's any further action that the commission would like to take in connection with the study session. So I believe it's time to move on to item number 10. Does staff have a presentation you want to make in connection with that?
Well, in light of the upcoming continued hearings on the agenda number 7, number 8, staff is recommending the final report is also continued to the January 18th meeting. That will provide staff to update the final summary activity for the 2010 election cycle for your commission to present to the Board of Supervisors.
You know, I did neglect to mention one issue in connection with what is noticed under 9, and that is the financial efficiencies of administering the ordinance. Staff has prepared an executive summary of the expenditures to date. The commission didn't discuss the amounts of money expended from fiscal year 2009 through the current time. Is there any need for further discussion about that before we move on? No, okay. Right, so do I have a motion to continue the Commissioner's report to the Board of Supervisors to our January meeting as recommended by staff?
Second.
Moved and second. Okay. Any objection? All right. Now, I have already announced that the next meeting is January 18th at 9 a.m. in these facilities. Is there anything else to come before the commission at this time? Motion to adjourn?
So moved.
We're adjourned.